Ladies and gentlemen, welcome to IHP 610 Health Care, Law, and Policy. In this course, we are going to be exploring several different concepts, and as we explore these concepts, there will be room for personal opinion and views. We need to avoid the interjection of personal opinions and personal viewpoints and political viewpoints during the course of this class. This is a class that is based on objective information, rules of policy making, the Constitution and existing laws, and public policy. You will have an opportunity in some of the postings and discussion forums to disagree with a fellow student. I encourage respectful dissension and disagreement. I also must insist that if you are going to have a difference of opinion, that you support your difference of opinion. As we move forward into the course, we will move into specifics of healthcare laws and policies that are in place and those that are being proposed at various levels. I will make an emphatic statement from the very beginning of this course. Our healthcare policy rules and regulations are governed by the rule of economics. And many of you may feel that economically we are unrestricted as a government and with the ability to tax as much as we want, that federal and state spending on healthcare should be an unlimited priority. However, when we look to the definition of economics, and that's the allocation of resources under conditions of scarcity, we must realize that we have scarce resources. And we must respect and understand that depending on your political viewpoint, you have a different view as to whether or not the government should have unrestricted spending. We will cover the constitutional right to health care later on in this lecture, and we'll specifically discuss those two areas that cover that. If we look at healthcare policy and law, there is no dispute whatsoever that it is a very invasive aspect of the system. The prevalence of spending and regulation in the healthcare industry by the federal government is without question, and without it, we wouldn't have a successful healthcare system. Today, the healthcare industry is regulated and influenced in many different ways, and federal and state policy and law will impact all aspects of the healthcare system. The way the laws and policies and regulations influence healthcare are the following: by direct law, laws against abortion, laws against certain practices that endanger the environment, regulations by the CMS, Center for Medicaid Services, and the Department of Health and Human Services, spending, terms of contract. Contractual terms are a matter of law. Contracts are used between healthcare providers, healthcare institutions, and insurance providers. Terms of participation. When we talk about Medicare and Medicaid, many of the aspects of Medicare and Medicaid are not direct regulation, but instead are imposed terms of participation. And if you're going to participate in the Medicare and Medicaid program, for example, your healthcare facility must reach JCAHO standards and accreditation. And then last but not least, by litigation. Healthcare is indeed affected by the interpretation of laws that have been passed on the federal level. It indeed affects the healthcare industry, and many would argue the healthcare malpractice crisis has indeed overcompensated for the care of individuals and results in unlimited and unnecessary testing. Our author divides the health care and policy domains into three large topical domains. Keep in mind that all of these domains are not exclusive. They're not in their own little tunnel. They're not independent of other. They are indeed dependent of each other. And which domain you accept and that you view the industry from will oftentimes depend on the particular industry that you're involved in. The healthcare and law domain is concerned with the individual's access to care, the quality of care, and the financing for that particular care. We often, and particularly in our healthcare policy, one of our first classes, we address things from the issue of healthcare access, quality, and cost. Public health policy and law is what we are going to focus on for this particular course. The focus here will be on why and how the government regulates private individuals and corporations in the name of protecting the health, safety, and welfare of the general public. And I've got just a little trailer here that says imagine. Could you imagine if we didn't have a healthcare system that regulated through licensure what doctors, dentists, or other healthcare providers could provide services to individuals? It would be a nightmare. The three working definitions of policy that are provided by our author, actually, sorry, I must back up. I skipped a couple here. The next domain is bioethics. And when we look at the bioethics domain, we are addressing biomedical research and appropriateness of medical intervention and treatment in relation to ethical standards and care. The most common example here would, of course, be human genetic cloning, cloning in bovine and swine to transplant into humans would be a great example. And I skipped over public health policy and law. The focus is how the government regulates. No, I did cover that one. Sorry. So now let's talk about policy and law. And we got a good quote, and I really like this quote, the way it was set up by our author of our text. Policy and law have long been used to cause social change, and neither the healthcare nor public health field is immune to it. Thus, going forward, there is little reason to expect that policy and law will not be the two primary drivers of the healthcare field. Our author provides us with three different working definitions of policy. Please go over those definitions of policy. I will not read them here, but I would like you to be familiar with the three working definitions. An important aspect to these definitions is whether or not private actors or public or government actors is involved. And as we will see, public and government policy making will occur in the healthcare industry. Many ask and question whether or not this should be a government-only domain. An important aspect of whether policy maker should be a public or a private figure, you must concern that the decision that is rendered, whether it is by private or by public, is one that has authoritative enforcement ability. You can't just have policy and then not have a way to enforce it. The decisions on an individual or group with power to implement the decision, and there are a variety of levels where these kinds of decisions can take place. I would suggest to you that some of the private agencies that have power over policy are directly related to the financing of healthcare and how our healthcare industry functions, such as licensing boards, licensing and credentialing departments for private hospitals. Another aspect of policy at a different level is whether a decision represents a policy or whether it is a question at hand of an individual concern. So when we talk about an individual concern, we would be talking about the micro level of decision making in healthcare institutions. If a large healthcare institution makes a decision in a particular market that affects and impacts the entire community and industry in that particular area, you now have something that is a macro decision. If a healthcare institution makes a decision for itself, then of course you are merely talking about a micro decision. Public policy problem goes beyond the individual sphere. It captures a concern and a need that is demanded by and will fulfill public's needs. Policy and laws are not always structured such that they prevent people from acting or refraining from acting in a certain way, but oftentimes can compel people to act a certain way. And an example of that would be Food and Drug Administration laws that compel manufacturers to follow certain standards. When we talk about the state versus federal aspect of policy making, we must remember policy must be consonant with the federal law and constitutions. Both states and federal government do have the authority to create laws, pass laws, affect laws, and have a judiciary, a executive, and a legislative branch involved in the process. The U.S. Constitution and Supremacy Clause holds that all authority and power relative to federal matters remains with the federal government. It also holds that the federal government has the ability to delve into state matters and impact state laws that are in contradiction of the U.S. Constitution and federal law. The state policy level is a policy-making level that will basically deal with many of the same issues that we see at the federal level, but they relate to individual state concerns and needs. For example, the provision of Medicaid is indeed directed by the state level, but it also has a federal aspect too, because there are federal guidelines and conditions for the receipt of federal Medicaid funds that fund a state program. Like the federal government, each state will have its three branches of government: executive, legislative, and judicial. At the federal level, we have the federal government involved in issues that concern all states, that concern the way the states interact with one another, the way that government and businesses interact with one another. The remainder of this course, we are going to focus on federal law and policy making for the most part that relates to health care and the healthcare industry. The federal legislative branch is empowered by Article 1 of the U.S. Constitution, which makes the U.S. Congress the lawmaking body that has all legislative powers and right to enact necessary and proper laws to effectuate its prerogatives. 5 congressional responsibilities are fulfilled by the 2 chambers of Congress, the Senate and the House of Representatives. We collectively refer to Senate and House of Representatives as Congress. Congressional power includes, but is not limited to, power to levy taxes, collect revenue, pay debts, provide for general welfare, regulate interstate and foreign commerce, establish federal courts inferior to the Supreme Court, and declare war. Up until recently, we didn't consider this a function of government, but in our recent past and in the 19th and 20th century, we were living within our means up until the mid-20th century. Now many consider it's the prerogative and the authority of the government to borrow money, which is a hot potato and debatable issue. There are 3 committees that are very important in healthcare policy making. The first is the CBO, or Congressional Budget Office. And up until recently, the CBO remained and appeared to remain neutral. However, in the last 2 or 3 decades, we have seen the CBO become a partisan function depending on who is in power or what the majority of composition is of the CBO politically. The last 3 remaining do indeed appear neutral and have remained neutral. The CBO provides the Congress with cost estimates of bills and federal mandates to state and local governments, as well as forecast the economic trends and spending levels, particularly those spending and economic trends relative to proposed proposed legislation. For example, the CBO ranks the ACA, ranks the changes that are suggested to the ACA, and so on. The Government Accountability Office is an independent, nonpartisan agency that studies how federal tax dollars are spent and advises the Congress and executive agencies about more efficient and effective ways to use federal resources. They're an oversight committee. The Congressional Research Service provides nonpartisan research that is objective and is basically a compilation of data and an extrapolation of data from various sources presented in a nonpartisan manner, which is available for many of the other agencies to draw upon to use to make their conclusions and recommendations. For example, the Medical Group Management Association, the American College of Healthcare Executives, they will draw upon data relative to and research done by the Congressional Research Service to make their conclusions and forecasts. And then last but not least, and this is one that's huge for the healthcare industry, of course, is the Medicare Payment Advisory Commission, which is an independent federal commission that gives Congress advice on issues relating to the Medicare program, including payment, access to care, and the quality of care provided by that program. I have listed here in the next 3 pages many of the different committees and subcommittees that function relative to healthcare, and specifically they're broken down by the name of the committee or subcommittee and what they have jurisdiction over. I suggest you take a look at those because those will directly impact, ladies and gentlemen, the research and the work that you will do for this course in the future. Then our last table, basically what it does, it summarizes the functions of the Congress, President, and administrative agencies. It also summarizes the tools and powers that those branches of government use to effectuate their agendas and programs. And last but not least is it tells you who their constituents are. When we look at the legislative branch, we were looking to Article 1. Article 1 empowers the legislative branch. When we look to the executive branch is empowered by the Article 2 of the U.S. Constitution, which establishes the executive branch and vests all executive power with the President of the United States. The President carries out his policies through 15 cabinet departments that are led by individuals selected by the President, subject to Senate confirmation. The judiciary is one of those, and we are seeing a huge nightmare when it comes to the judiciary in the last couple of weeks relative to Kavanaugh nomination. We will, of course, need to understand that each of these departments, or I'm sorry, not departments, but cabinets, cannot function without their head, and then with those individuals and departments within each of the cabinet levels. And your book does a pretty good job summarizing and setting forth those cabinets and cabinet positions. And when we look at the duties and responsibilities of the President, we are looking at a responsibility of interpreting and implementing those laws passed by Congress from a enforcement aspect. The advisors will advise the President of the United States with policy options for him to consider. In theory, all of these parts of the executive branch work in furtherance of the goals set by the President, known as his agenda. The President is the head of the federal executive branch. Agenda setting is the key tool available to the President. We've seen that, whether you agree with it or not, we have seen President Trump's agenda be more focused on, at this point, trade and industry. He's also had a focus on world peace through the North Korean aspect and the sanctions against Iran. He has promised, and they are moving towards trying to phase out Obamacare. The first attempt at that is through the last Tax Act, which did away with the federal mandate. Whether your position is either way for or against the ACA, the one thing that we do need is stability. And unfortunately, every 4 or 8 years, we get a new department head for the Health and Human Services. We get a new director of the Center for Medicaid Services. And every 4 or 8 years, we will have a major change in the healthcare system. I don't know if there's any direct answer to this. As a proponent of keeping healthcare the same and stable for at least a substantially definite period of time, my suggestion would be to move the department head for Secretary of Health and Human Services to a lifetime post. So at least we have consistency. I think one of the most costly aspects to healthcare policy and law is the fact that we don't have consistency. So then if we move on, ladies and gentlemen, for the agenda setting, when we look at agenda setting, party loyalty has historically played a major role in whether or not the president's agenda has support of the entire party, which it usually did in the past. During the recent developments of the 21st century, we've seen groups like the grassroots Republican movements. I just went blank for the name of the group, but the far right constituents that have an impact on the Freedom Caucus movement. We have a lot of different pulling forces, and they are affecting whether or not agendas are successfully implemented. They've affected both, all three: Bush, Obama, and Trump. I don't know how we ever get that aspect of interference and or manipulation of the agenda. And of course, the most important department that we look at relative to healthcare is the Department of Health and Human Services. And the DHHS includes hundreds of programs that cover activities as varied as medical and social science research, preschool education services, substance abuse and prevention services, health insurance programs, just to name a few. We have a chart, table 2-4 from your text, which does a pretty good job of summarizing some of the key and important agencies in the DHHS. So now we move on to the executive branch and its ability to enforce the law. We have the Department of Justice, which oversees the FBI and federal marshals. The Department of Justice has the authority to enforce the law through federal bureau or through federal marshals. If a court issues an order, the federal marshals have the ability to go out and seize property, seize individuals in the form of arrest and incarceration, and do what is necessary to ensure compliance with the law in our legal system. When we look at the judicial branch, we look at the sources of law, which are outlined in Table 3-1. I suggest you take a look at that. Basically, we have the Constitution, we have statutes, we have regulations, and we have common law. I would suggest to you, ladies and gentlemen, that our author forgot one of the sources of law, and that is equitable jurisdiction. All courts have what's called equitable jurisdiction, or the ability to sit in equity. And what equity is, if there is no federal, state, or local statute or rule or ordinance that addresses the issue and or does not equitably resolve the conflict, the court has the right to step in and fashion remedies that will address the issues in specific instances relative to a dispute. We have 3 courts at the federal level. I would suggest to you that the federal and state courts are quite similar, with the exception that they vary in structure and appellate rules. The law reaches into every aspect of our lives in the 21st century with few exceptions. The state and federal laws have always been intended to afford Americans with civil liberties and the ability to live and worship as we please. For the most part, this still holds true, and we enjoy unsurpassed freedoms in the world as compared to other countries. The hot potato in this particular discussion is the concept that we have certain issues that are not covered or adequately addressed by the federal and state governments. I'll let you determine which of these issues you feel are important and those that engender a response from the government in your mind, but we will avoid those issues that do not relate to health care. A constitutional right is a power or a privilege, and it has been guaranteed by the United States Constitution to each and every individual who is a citizen of the United States. Some have argued that something is a matter of governmental discretion can be considered a right under the Constitution's umbrella of life, property, and happiness. However, a strict constitutionalist will remind you that we have a right to the pursuit of life, liberty, and happiness in a statement in the Declaration of Independence. When we look at the governing meat of the Constitution, there are two articles and amendments to the Constitution that deal with life, liberty, and the pursuit of happiness. And those both are a negative. They both restrict the government from interfering in our pursuit of life, liberty, and happiness, or from interfering with our property and our individual speech and individual beliefs and practices, so long as they are consonant with the Constitution. The Constitution states in Article 4 and the 14th Amendment that the government cannot deprive any person of life, liberty, or property without due process of law. The argument that we are guaranteed the right of health care as a fundamental right, let me restate this because it's very important. The argument that we are guaranteed the right to health care as a fundamental right under the Constitution is indeed flawed. The only way we can change that is through a constitutional amendment. And that can be done through grassroots movements and individuals in each and every state. I'd like you to take a look at Black's law definition of what a law is. And I'd like you to realize that laws are not concrete, and that's where adjudication comes in. And adjudication is the legal process of resolving disputes. Specific legal disputes are resolved by the judiciary. The judiciary indirectly does make laws when it sets a precedence under common law and or it interprets the authority to interpret laws passed by federal and state governments. Our judicial system is the last thing we'll talk about. And one of our key tenets in the judicial system, it is prospective. All states in the federal government have what's called ex post facto laws. You cannot apply law to previous events, occurrences, or disputes. You can only apply law prospectively. The application and interpretation of law in the realm of the judiciary, who has those broad powers to resolve issues of contract, criminal, administrative law, as well as issues of equity. The federal government and the majority of the states have a three-tiered judiciary. Some have more. At a minimum, the following levels are seen in our different jurisdictions. A Supreme Court, which is the highest court in the system, a Court of Appeals, which is the second highest court, and the District Court. At the federal level, the District Court is considered the court of original jurisdiction, and appeals go upwards. The federal courts have the jurisdiction over federal matters, federal laws, federal controversies, constitutional issues. However, the federal Supreme Court does have, through a process called certiorari, the right to grant permission in cases where the Supreme Court feels that the law, dispute, or issue being challenged affects all of us on a federal level. And that's where you will see in the news that the court has agreed to hear. The Supreme Court agrees to hear a case through a writ of certiorari. Many states have added other levels due to the number of cases, and the separation is determined oftentimes by the value of the dispute or the nature of the crime. For example, the Supreme Court is still the highest court in the system and hears all state cases on the state level. The Court of Appeals is the second highest court and will hear all appeals from lower courts. Circuit courts in many jurisdictions hear felony court cases. They hear controversies on a civil basis involving $50,000 or more in controversy. The district court will hear cases of misdemeanors and controversies of $50,000 or less. So what we look at is, in some jurisdictions, an additional layer which is called the small claims court. The federal courts also have the ability to review the actions of political branches, and in so doing, the federal courts do set policy and law. The case that granted this authority is Marbury versus Madison. And what happened here is President Madison took over, and before Madison was elected President of the United States, certain offices were created by his predecessor. When it came time to fill the vacancy of the newly created offices, President Madison refused to seat these individuals. And then we had the case of Marbury versus Madison decide that the federal courts can review issues of this nature and like. I would also state that when a judiciary at the federal level makes a decision that impacts all jurisdictions, that it then becomes a form of policy making. One of the key purposes in the law is maintaining stability in society. We want stability, continuity, and certainty in our legal disputes, in the use and spending of federal and state funds, and in the regulation of certain industries such as healthcare that have a potential for high levels of abuse and to take advantage of citizens of the United States. With that in mind, ladies and gentlemen, I will prepare a separate lecture relative to your DQs and journal entries, which will appear in week 1. If you have any questions, you are always free to call at 801-940-2531, or you can email me, of course, at p.vanash@snhu.edu. With that, ladies and gentlemen, I hope that you enjoy this course and that you learn a lot and that you share a lot and that we learn together in this mutual learning environment.